It's interesting.
May it please the court, my name is Stuart Graham, counsel for the defendant, George Nardi. In this appeal from his conviction for first-degree murder, Mr. Nardi raises three issues. First is whether the use of an expert witness to present the autopsy findings and conclusions, as well as an opinion of the expert, violated Mr. Nardi's Sixth Amendment and Article 12 rights.
Well, do you agree that both parties stipulated that Dr. Weiner, the medical examiner who conducted the autopsy, was not available to testify due to his retirement in Florida and his medical condition?
Correct.
And your brother says that the testimony, the autopsy report was never admitted into evidence. Do you agree with that?
The physical autopsy report.
The physical document
All right,
itself
was not admitted into evidence.
But the autopsy report itself was admitted into evidence through the expert witness.
Well,
He testified about statements that were contained in the autopsy
He
report.
testified to almost every detail in the autopsy.
And this was on direct examination?
On direct examination.
Reading from it?
At times. Yes.
well, your brother also says that the testifying expert made it clear that his opinion was based on his own assessment of the factual information, photographs, and microscopic tissue slides developed during the autopsy. If he did that, what's your complaint? If he said, this is based on my own assessment,
His own assessment is based upon the findings and conclusions in the autopsy report. He takes those findings, those conclusions, his view of the photographs, which were unauthenticated, and his view of the slides, both were informed by the findings and conclusions of the autopsy report.
So how do we do this? I was trying to think about, all right, well, that's an interesting argument, but lots of medical examiners die by the time cases come up or retire. They've left the jurisdiction. They've done a whole series of findings. There's pictures, there's descriptions of the various incisions that they've made and what they found. Is your argument that that stuff simply can never come into evidence if the medical examiner is no longer available? That no subsequent medical examiner can review that material and testify about it?
That's correct.
Wow.
Well,
Right.
but are you also saying that a pathologist cannot review all that material, which is, at least if there were a witness that was able to testify to that stuff, I think, presumably could all come in, and it's hearsay, but you can rely on hearsay that is otherwise independently admissible and give an opinion. Why wasn't the opinion, let's break this down, why wasn't the opinion itself admissible?
Yeah. If I can back up just a bit, because that is the central part of the argument. First, we have to establish that the autopsy report was testimonial, is testimonial.
No. Wait. I'm just asking you about the opinion. I'm not. I know that there's a hearsay problem.
Dr. McDonough's opinion, the second
Yes.
pathologist,
Yeah.
right?
Well, if I may, the autopsy report is testimonial. The statements in the autopsy report are testimonial.
Right.
But that doesn't mean
All right.
that doesn't mean that the pathologist McDonough can't rely on them.
Well, I can answer two ways. The first part is, if the medical examiner testifies, or if the defendant stipulates to the facts in the autopsy report, of course the medical examiner can rely on that.
I take it what you're doing is you're sort of engrafting Crawford onto the case of the Department of Youth Services versus a juvenile.
Precisely, Your Honor.
Okay.
What my argument is that independent admissible provision of Department of Youth Services in a criminal case has to be understood to require that the facts upon which the expert is relying are presented to a jury through a recipient witness. Otherwise, the Sixth Amendment is just evaded.
No, it's not. It's you could cross-examine the expert about the basis for the expert's opinion, about his credentials, about a lot of things.
In order to cross-examine the expert as the basis for his opinion, the defendant has to elicit the basis for that opinion. The basis for the opinion are the findings and conclusions in the autopsy report.
But there are also the photographs and I forget, there was something beyond
Slides.
photographs. Slides, yeah.
The
Yeah.
photographs were not authenticated.
What does that mean, not authenticated? Are you suggesting that they weren't taken at the autopsy?
The
I mean, isn't that a
pathologist,
technical
the expert witness
problem?
had no idea when they were taken. He couldn't identify them. He couldn't say, I got these from the medical examiner.
Oh,
He couldn't
that's-
say, these were of the autopsy, of this individual. He couldn't
Well,
say any of that. When
But
photographs come
that's
in,
a solvable, I mean, that's a technical
wait a second,
problem.
Was there an objection on that ground at
Yes.
trial?
There was.
And did the judge say anything about the nature of that particular
Judge
objection?
overruled it.
Well, did the photographs come into evidence?
Yes.
Well, was the objection to the admissibility of the photographs or to the doctors relying on them?
There was a general objection to the entire testimony of the expert on Sixth Amendment grounds. There was a specific objection to his testifying about the photographs and the photographs coming into evidence because they were unauthenticated. So on both grounds, Your Honor, there were objections that were preserved.
So it's
Was
really
it
a chain of
disputed that the pictures were of the victim? I assume these are photos of the
Well, it's not for the defendant to dispute that.
No, but I'm just saying, I'm curious, the autopsy photos seem to be fairly unique in that sense. It's not something you'd find in a
Not
file
fairly,
somewhere.
I'd say they are unique.
Well, in order for a photograph to be admitted into evidence, the general rule of evidence, it has to be authenticated. There has to be somewhere one to say, this photograph represents what it purports to represent, that it is a clear, accurate representation of the condition that are shown in it.
Was there any
That's
state,
important. That's not a technicality.
did either a state police photographer or a state police officer who was attending the autopsy testify about the photographs?
No. And that's the
But
problem. There
is
was
there
no
any
authentication
reason,
of
do
these
you have any,
photographs.
but, okay, and I understand it's not your burden, but is there a substantive doubt that they were of the victim?
I am not in a position as appellate counsel to say what trial counsel doubted or did not doubt. All I can say is his objection was that these photographs are not authenticated. And the reason for that is the photographs were purported to show some evidence of trauma. When were they taken? Were they taken of this victim? Was there some problem with it? We don't know.
Did they show the face of the victim?
I think they showed only portions.
Some of them did because they talk about bruises on her jaw.
That's right, they showed portions. a
And were there
side of the
were there
face.
other photographs of the victim introduced?
Not that I know of.
So no one even looked at the photograph and offered testimony that the person who's depicted in this photograph is the victim.
That's correct. Now, if we get back to your original, I think, Justice Smear, your original question, as is, can the expert just give his opinion and not the facts? That's what Marquardt, I think, says. And our answer is, in a criminal case where the expert's opinion is based almost entirely on the autopsy findings and conclusions, for him to give his opinion without that evidence being introduced is merely to restate or reaffirm the findings and conclusions of the medical examiner without the medical examiner's findings and conclusions being subjected to cross-examination. Crawford requires, the Sixth Amendment requires, the defendant have the opportunity to confront and cross-examine the witness who developed the facts against them. I think there's a quote from Poynter v. Texas to that that makes that point.
Well, are you saying then that in all cases, we have to figure out a way to guarantee that the person who does the autopsy is available for trial? That we can't ever have a situation where the person is unavailable due to death or illness or retirement or anything like that, in order to be able to confront the witness? That
Your Honor-
seems like you're saying that.
It
You
does
are
seem like
saying
I'm
it.
saying that.
I mean, what are you
And because I
saying?
am saying that.
Yeah.
And why I'm saying that is because that was Massachusetts practice prior to Department of Youth Services. The facts on which an expert could rely for an opinion were three: facts within his own knowledge, facts that were offered into evidence, or facts that were admitted by the parties. That was the law in this Commonwealth prior to youth services. So all I'm saying is we should go back to the practice in a criminal case, not in a civil case. Sixth Amendment doesn't apply. All we could do is go back to the practice prior to Department of Youth Services for criminal cases.
Has any other jurisdiction ruled on the question of either state, highest state, or federal appellate court on the question of whether Crawford applies to the bases on which an expert gives an opinion?
I could not find one. There are some decisions going both ways on autopsy reports themselves, but most of them say they are testimonial and can't come in.
And that's actually before the U.S. Supreme Court in one
And that
form.
is.
Yeah.
Why doesn't this go to the weight and not the admissibility? You're saying because of the
Because of the Sixth Amendment.
because of the Sixth Amendment.
That's correct. Sixth Amendment is that fundamental guarantee that before you put facts before a jury, whether in the form of an opinion or the facts themselves, that they be subjected to cross-examination.
Was the death certificate admitted in this case?
I don't believe it was. But,
So it would be the same argument on the death certificate?
Yes.
That-
No, that's admissible as a business record.
it would be the same
Why
argument.
isn't that
as
admissible
an
as
public
a
record,
public record?
Yes, but
That's
he would say
admissible
the
as a public
Constitution,
record.
he would
No,
say the
I would
Constitution
say
says no.
that that is a testimonial document. That is, the cause of death, homicide, whatever.
No,
is
it's required by statute for all sorts of public
Yes,
health
but
and other
He's
reasons.
saying Sixth Amendment.
The Sixth Amendment
prohibits
trumps
it.
that.
But Crawford limited, it said that it applied except for certain exceptions. I mean, it is testimonial. Crawford only applies to
That's
testimonial.
correct. I'm saying that the death certificate is testimonial.
Well, surely to the extent that the autopsy report has the conclusions as to the cause of death, those are presumably professional opinions,
That's correct.
right? Those would clearly be testimonial.
That's
I don't
correct.
think there's any question there.
Why wouldn't they be prepared for a public health purpose? The statute requires.
They're not public records.
No, but
Pursuant to
there's a
Commonwealth
public
v.
health
Slavsky, they're not, you're correct, they're not public records. They don't come in as public
But I
records.
say they're not prepared for prosecution. They're prepared for public health purposes.
There are two answers, Your Honor. The first is, to be testimonial, you have to know or have reason to know, or to believe, that they may be used for investigation or prosecution,
Okay.
not that they have to be.
Obviously, we'll have to look at but is a copy of the autopsy report in the record as an exhibit? I know it didn't come into evidence, but was it marked
Not an
as
exhibit.
was marked for
I
identification?
don't believe it was marked for that.
Were there
But
two I'm sorry.
we have the testimony of the expert who actually testified based on what.
You have almost all of the autopsy
Okay.
report through the testimony
And
on
what-
direct examination, which is itself a violation of Massachusetts law.
I understand your
You
argument.
don't have to go to these other issues. can just
You would
rely
say
on-
that violates Jaime. Is that right?
Yes. Allowing him to testify to all those facts on direct examination is a direct violation of Marquardt and
Jaime.
youth services.
Well, it's really that part, I think, if I'm saying that correctly, is because on direct examination, he should not be able to testify to the facts that go to base his opinion. I think that's the Jaime, the Commonwealth versus Jaime case. Yeah.
That may be, it's also Commonwealth v. Marquardt.
But on cross-examination, he can be cross-examined about the underlying facts that.
That's correct. If I may-
Was he?
No, this was on direct. Well, this was admitted on direct examination.
Yeah, and if I can address that, because that is an important issue. That is, what the provision does is place an unconstitutional burden on the exercise of the defendant's Sixth Amendment rights. He is presented with a choice either of not challenging an expert's opinion or cross-examining and eliciting the facts and thereby waiving his Sixth Amendment rights. That is an undue burden on the exercise of those rights, and it can't be sustained in face of the Sixth Amendment right to cross-examine the medical examiner on those facts. So merely saying, well, you can do this on cross-examination if you want to, Mr. Defendant, but you're going to waive your Sixth Amendment rights if you do.
This is always a painful exercise. Trust me on this. But just for clarification, and again, it will be in the transcript, what the expert testified to was what the medical examiner who actually did the autopsy, what was observed. This incision was made, bruising was observed
That's correct.
in the incision, That's the kind of stuff those are the facts, right?
He went even beyond that. That it testified to what his state of mind was, why he did something, because he saw something here or he believed something to be there.
And was that based on the autopsy report or on his conversation with
It was based on the autopsy report. He's looking at the autopsy report and explaining what the medical examiner's mental activity was.
Were there two autopsies or just one? Because it was
Well,
a
I
little
think it's
unclear to
best
me.
said there was one autopsy with two examinations.
But Dr. McDonough, do I have the name right for the second one?
correct.
I think there was an indication he actually spoke to Dr. Weiner at some
did,
point, and then he read the report. He looked at the photos and slides,
Well,
and whatever samples
we're
there were.
not sure about the photos, whether he
Okay.
looked at them at that time or not, because he couldn't identify them as being the ones that Dr. Weiner showed him. They
Your
were
brother says that Dr. McDonough did not speak to the first doctor until after he had independently reviewed the factual material. Dr. McDonough wanted to avoid having his own opinion subtly biased by Dr. Weiner's opinions.
I think it's irrelevant when he spoke to him, because
Let
what he
me-
reviewed was his autopsy report. So he doesn't talk to him about the autopsy report. He just reads what he says in the autopsy report. I think that's a distinction without
How
difference.
is this different from Commonwealth versus Verity?
The facts of that,
The drug
That's a
analysis.
drug
Drug
examination.
analysis.
That's a drug analysis.
Drug
case.
analysis.
the drug analysis. Well, I think, obviously, that is before the Supreme Court at this time, and I think it's clear that, well, I shouldn't say that. It is our opinion that those analyses are subject to the Sixth Amendment. However, it's different because a drug analysis is rather technical. And there is not the facts, the specific facts of what I did, what I saw, why I did this, what is this, what's my opinion as to whether this is or is not a bruise, this is or is not trauma, there is or is not heart disease. Those are really fine medical distinctions that are subject to cross-examination, even in civil cases. Those kinds of facts are not involved in a drug analysis. This is precisely what I think what the court had in mind when it talked about testimonial in fact.
And I take it that cause of death was the issue in this
Cause
case.
of death was the primary issue in the case.
I don't want to have us just focus on this first issue. You've got about 2.5 minutes left if you wanted to.
Yeah, go finish. I have a question on the issue of the check. Did the defendant admit that he had written the check?
I don't believe in the transcript that the defendant admitted anything.
Did he say to the...
He didn't testify.
But did the neighbor, the woman, testify that the defendant gave me a check and said he had signed it?
She said he gave her a check. She did not look at the check, so she
No,
could
no, I
not.
understand that, but did she say that he said he had signed it?
Your Honor, I frankly don't recall. I would not be surprised if she did say that. But
Well,
I
that's a
don't
big
recall.
point, because then if she says that he said it, then the check, that authenticates the check.
Doesn't authenticate this check because she never saw this check. She didn't look at this check. She couldn't say if this is the check that he gave her or not.
Okay, and your objection was that they didn't subpoena the records of the bank. I mean, when is that
That's correct.
required?
That's required whenever they're available by subpoena. That is, if you're going to authenticate a document, you
But
have
you
to
wanted
have...
the judge to stop the trial, keep the jurors waiting until the next day when the bank person could come in and bring in the records of the check.
No, absolutely not. I want the Commonwealth to do their job according to the rules of evidence and subpoena that in before trial. And if they don't, they suffer the consequences. That's what I want. I want the Commonwealth to be held to the same rules of evidence that the defendant is. If they don't subpoena those documents in before evidence, they don't go into evidence. That's what we're saying. Well, I see.
You have a minute left if you'd like to use it.
Very quickly, and this is regard to the erroneous jury instruction, although I'm not going to be able to address it. Basically, I know this is the model jury instruction, but what we're saying is it doesn't define deliberation. It conflates deliberation and premeditation. Deliberation refers to the weighing of the consequences of whether to act or not. In this case, the instruction was the defendant thought before he acted. That is, he decided to kill after deliberation. But premeditation, specific intent, deliberation are all thinking before acting. It's what you think about that's important. It was never explained what you have to think about, that you have to think about weighing the consequences. That's deliberation. Planning or considering it is deliberation.
But it's
Forming specific-
deliberate
I'm sorry.
premeditation. Isn't that what the statute says? Deliberate premeditation.
And the case, I think, Gibson is quite clear. That requires deliberation and premeditation. Different concepts, different mental actions, different consequences apply to that. You can premeditate an act without deliberating about that act, but the statute requires both.
But doesn't the instruction talk about cool reflection?
It talks about the resolution to kill after some period of time or cool reflection, but it doesn't say what you have to reflect about.
Well, I mean, it's the killing, isn't it?
How to kill him, whether I should kill him at this time or whether I should postpone it, whether there are witnesses, that's all premeditation. That's correct. It's not deliberation.
Mr.
Further,
Graham,
they instructed that
Mr. Graham, thank you.
Good morning, Your Honors. Robert Thompson on behalf of the Commonwealth. Your Honor,
Well, what's the justification for allowing the pathologist, I believe it was Dr. McDonough, to essentially testify off of the autopsy report? Isn't that a clear violation of DYS versus a juvenile?
well, Your Honor, certainly not of DYS versus a juvenile. DYS versus a juvenile just says that it accepts the idea that an expert can testify to facts, can base his opinion on material that is independently admissible. And this would satisfy that rule because the autopsy report, the direct observations, particularly the direct observations.
Okay, so he can give the opinion, but doesn't our case law say that you cannot testify to the hearsay material upon which you base your opinion on
Yes, it
direct
does, Your Honor.
examination?
Yes, it does, Your Honor, and that's in Marquardt in particular. It does say that. And this was, you have to say, might have been excessive in that line. There was no objection to that on that basis here at all on that basis. There was a Sixth Amendment objection, but there was no objection in terms of when it came in. Further, the defense witness, who was an
There was a
expert,
Sixth Amendment objection?
just a general, broad Sixth Amendment objection. Your Honor.
To
To the
admi-
testimony of the pathologist,
To Dr. McDonough's testimony.
Dr. McDonough.
To does insofar as it relied on the autopsy report,
Okay.
right?
Did-
And
did
but
he
there wasn't
actually-
anything in terms of, well, he could give his opinion, but he shouldn't be giving the facts of that opinion. There was nothing on the DYS versus a juvenile basis or the Marquardt basis. And in fact, the defense presented their own expert who did the same thing, relied on the same material and reacted to the same material, and in fact arrived at the same conclusion. So that
Well, then, if they
particular
all
point.
both had the same conclusion, I thought that this was the most important contested issue at trial, was cause of death.
Well, I don't understand that it is, Your Honor. Apparently, the defense must have been taken by surprise because they put on their expert who ended up saying that when I first looked at this material, I was not sure about the cause of death. It could have been a number of things, including a heart attack. But when I further reviewed the material and understood more about the whole significance of everything, and I saw the context of the whole death, and I was able to look at these things in greater detail, then I arrived at the conclusion that it is unlikely that it was any kind of heart attack, and that it was indeed consistent with a manual asphyxiation.
That's what the defense
Defense
experts
expert
said?
Defense expert. yeah.
Dr. Flumenbaum,
Dr. Florenbaum, yeah.
who was then the chief medical examiner
Who was the chief medical
at the
examiner?
time he gave this testimony.
Yes, Your Honor.
If the defendant, if the defendant calls an expert who's going to be relying on the the pathology report, does that did you know in advance that that was going to happen? Or did the prosecutor know in advance?
We knew that, I mean, I believe we had noticed that they were going to call Dr.
A list of
Fulham.
witnesses were provided at
Sure,
trial?
sure, yeah.
Does that constitute a waiver of the Sixth Amendment for purposes of this expert, the Commonwealth's expert in this case, giving the opinion?
The fact that they're relying on the same material?
Yeah.
It,
Well, is that going to matter?
Very much.
Because you've
I
already
don't think
said-
it does matter,
Yeah,
but.
because you've already said that they didn't object on the basis of Commonwealth versus the juvenile, and since this is the first degree, we've got to apply a substantial likelihood
Substantial
anyway.
likelihood.
So even if they waived it, we still have to apply a substantial
Right,
likelihood.
and they
so
said there is
back
no
to the same
substantial
place.
likelihood when there is really no ultimate dispute
Yeah.
about the cause of death.
Yeah, but
But
what
just
I'm
to
wondering
be
is,
fair, Your
is
Honor.
like in the insanity defense, or analogous to the insanity defense cases, where where there's a Fifth Amendment issue as opposed to a Sixth Amendment issue. The psychiatrist, the Commonwealth psychiatrist, can, the defendant can be required to talk to the Commonwealth psychiatrist without any disclosure to the prosecution of the statements being made, and where the defendant indicates that he's going to raise a defense of insanity. And I'm wondering if some parallel reasoning can be applied here.
If they, I mean, because they do intend it, by all accounts, they intended to I mean.
But were they only going to do it if
surprised.
you were going to do it first?
Well,
I mean, it was
I
part of
can't
your
speak for
case
them,
in
I
chief.
can't. Of course, it is part of our case in chief, and I can't, of course, say what they were going to do apart from this, apart from the Commonwealth's direct case in chief. Clearly, if they thought that they had a absolute basis for a directed verdict, perhaps they wouldn't have put it on anything, but they did. It does go certainly to the significance of the fact that of a reason, even a basis for them not objecting to this doctor presenting that material as a basis for his opinion, because they're going to present the same material as a basis for their doctor's opinion. I mean, which ultimately didn't come out the way they hoped, apparently, but.
Of course, if he was successful in keeping your doctor from testifying, he wouldn't have to call a pathologist.
That's possible, yeah. On the Sixth Amendment, if we can turn to the Sixth Amendment in whether the DYS material does implicate Crawford at all. If it does, then this material, at least as to the primary facts, observed the observations, the direct observations made by the medical examiner, included in the autopsy report, are primary facts contained in a public record produced by law. They come under Slavsky. They come under Verde. They come under the new case for the similar to the new case on ballistic certificates of Morales from the appeals court, and they are admissible independent of Crawford for that reason, Your Honor.
But we'll know the answer to that sometime in the fall, I guess.
Your Honor, I mean, just
Maybe in the winter.
I'm not sure if you. I attempted to do it. I can't pretend it was entirely exhaustive, but I did attempt to do a out-of-state research on how autopsy reports had been dealt with under Crawford, and what I found, Your Honor, frankly, was 15 out-of-state cases by appellate courts, not always the highest court, but by appellate courts. 15 said that autopsy reports were admissible independent of Crawford, either as business records or as public records. One case.
The reports themselves,
The reports themselves.
they
Your
aren't
Honor.
admissible here. The reports.
What?
The reports themselves aren't admissible here. I mean, do we have a case that says the reports are admissible in Massachusetts?
Well, Your Honor, I would say that under Verde and Slavsky that it's so far.
No, we have a statute that lets the drug certificates in.
But I would
We don't have
suggest
a
that that's not
statute.
necessary, Your Honor.
But we don't have a statute that lets the autopsy reports in. We have the death certificate can come in.
But under the appropriate, what I suggested, the appropriate Slavsky analysis is whether these are primary facts contained in a report made pursuant to law, done under a duty by law to make the report, independent of any investigation or any of that. And both the drug certificates and the autopsy reports would come in under that. And what
What
Slavsky
statute-
would say,
But what statute requires the preparation of an autopsy report?
it's in the, I'm sorry, I don't have it at the tip of my
But it's in
fingers.
your
It's
brief.
in my brief, Your Honor. It's in chapter 38. It's in whether, in the
Says the
medical-
pathologist shall report his findings or her findings
Yes,
to the
Your Honor.
medical examiner? Or words to
Or
that effect?
the medical examiner shall make a report. Yes, Your Honor. And that would cover the direct observations, the primary facts, I'm not trying to say it would cover the conclusions to be drawn from that, the exercise of judgment from that, but the direct observations, i.e. there was bruising here, or I cut an incision and this is what I found. I mean, that material could come in. And that's all that Dr. McDonough was relying on here. I mean, he did say, and I don't want to misstate, he did say that ultimately he agreed with Dr. Weiner, and that's to the degree that Dr. Weiner's ultimate opinion came in. But it was his own opinion.
But we may have to promulgate a rule that allows depositions of pathologists.
Well, Your Honor, I suggest that that's what the reports are designed to be in the first place, that they're designed to be this.
But
this
you always have to have I mean, there's no criminal case that uses a report like this that doesn't have a live body testifying about it. You can't just introduce the autopsy
Well, I'm
report.
not
Our
saying that we
jurisdiction.
did, and we didn't try that, and I'm not suggesting we have any intent of trying that, and we'd prefer to have a live witness and have a cross-examination of a live witness and have that put in. I'm not trying to say that. What I'm saying is that what I found in out-of-state cases, that there was 15-1 that allowed,
Some states do allow autopsy reports
do
to
allow
come in
autopsy
without
reports
a live
despite a
witness.
Crawford objection. That's what I'm saying. I'm not trying to say that we should change our rules to do that. That's not my point.
Gotcha.
Do we have any cases that say the autopsy report is not admissible? I mean, I never thought it was.
There was an old case that's cited by my brother that referred to in Slavsky that says that at least insofar as it has opinions and conclusions, an autopsy report is not admissible. That's a Jewett, I believe, Jewett versus.
Okay. What about the check? Apparently, or let me ask you, did the defendant admit to the woman that he wrote a check?
Your Honor, I'm not sure. My brother testified. He said that the defendant didn't testify in this case. It was
No, but the
my
woman
memory that he
then-
did indeed testify and did indeed on the stand admit that that was the check that he passed to the woman. I don't know that if he admitted that he wrote her name on it. I'm not sure he admitted that, but that he identified that check during the defense case.
So that would authenticate the check.
But the woman who received the check saw the check, looked at it, and said, "Yes, that's
No,
the check that I turned in."
I haven't read the transcript, but I thought her testimony was that she didn't look at the check. That's what
She said
created
that I didn't
problem.
pay that much attention to it at the time. She said that. Then she was handed the check. She looked at it and said, "Yes, that's the check. It's got my signature. That's what I turned. That's the one I did."
You said at trial, Paula identified a copy of the check for $120 she cashed that day.
That's exactly, Your Honor, and that's the way the sequence went. Do you remember exactly what the check did? No, I didn't look at it that closely. Well, here, do you see this? Yes, I do. That is the check that I turned over that day.
Was her endorsement, a copy of her endorsement on the back of the check? Was it one of those kinds of?
I believe so. With her signature? Yes,
Yeah.
I believe so. So she could recognize it, if by nothing else, then her signature on it. In terms of the, that's in my brief. Your Honor, on terms of the deliberate premeditation issue here, the judge gave the model and jury instruction. The instruction said that there had to be a resolution to kill, that the resolution to kill must be the product of some period of reflection. This court has said that that is sufficient as an instruction. I cited Commonwealth versus Sereno, 436 Mass 408. There simply is no case that says that deliberate premeditation must include some kind of actual exercise of an opportunity to consider the wisdom of your actions, to consider the pros and cons before you do that. It may be, as a practical matter, that of necessity that there is an opportunity in this period of reflection to do so, that there's an opportunity to, or at least maybe the capacity under Commonwealth versus Gould, which is has to do with what kind of psychiatric testimony might be coming on these things. But it may be that there's at least the opportunity, but there's simply no case that says that the Commonwealth must show that the defendant actually considered the wisdom of his actions before he went forward. It suggests that's
Black letter law.
that's black letter law. Certainly, I'll say that, Your Honor. Well, Your Honor, unless there's any other questions, then I'll rest.
All right, thank
Thank
you,
you.
sir. All right.
All right.